fact that in municipal court, when the defendant requests a civil reservation, it is routinely granted. However, in order for it to be granted, the defendant has to be present in court. You can't have entered a plea by, a guilty plea by mail. In order to ask for the civil reservation, that body has to be in court. Okay? There has to be notice given by the municipal prosecutor to the victim. The victim has to have the opportunity to come in and object to it. The time that you ask for the civil reservation is at the time that the plea is entered. You don't wait and do it 2 weeks later because you think, oh shit, I forgot. Okay? You have to do it at the time that the plea is entered. They're very specific about that. Okay? And they talk about the fact that it only can be non-evidential if the civil and criminal charges rise from the same transaction. But if they don't, if they have different elements or they have different concerns, then a civil reservation isn't appropriate. In this particular case, the failure to report an accident conviction was not admissible in the civil proceeding to prove negligence, and therefore a civil reservation was not appropriate. So it has to be, the conviction has to go to help prove the negligence or whatever you're trying to allege in the civil case. Okay? And then the civil reservation is appropriate. I think that that's splitting it a little bit too nicely. I don't think that the municipal courts are going to take the time to really sit there and analyze what the prospective civil case could be based upon and whether this particular action might or might not be used to prove it in the civil case. I think they're going to say, defense, you're requesting a civil reservation. Victims, do you have an objection? Okay, what's your basis for your objection? Okay, and then either grant it or deny it. I just don't think they're going to go through this in-depth analysis.
I've never seen any cases dealing with what your cause is or how to grant civil reservation.
I have them. I can give it to you. It's been a while since I did the research. But I had to do it when I was a prosecutor.
Based on that case, the prosecutors are more sensitive to victims when they show up.
Oh yeah, they have to. They have to notify them too. But fortunately for civil attorneys, there is a whole other line of civil cases that deal with the request for civil reservation. Because then you can actually go to your civil, if you're the criminal, civil defendant, you can actually go to the civil judge and you can request a civil reservation of that conviction from the civil judge as well. So I found a whole bunch of cases when I was doing that research. They really weren't on point for me, so I just kind of ignored them, but I remember that they were there. So it's not like you're completely prevented from doing it. If you do make a mistake, there is still a remedy, and it's in the civil case itself. Okay? Yeah.
If you're in municipal court, your client's in Florida, the victim's there, put the plea all the way through subject to the client. Saying that, I don't see the reason why you would be able to ask since the victim's there for that civil reservation.
Well, because the case, the Supreme Court specifically says that in order to obtain a civil reservation, the defendant has to be physically present in court. I mean, it's not like a dicta, wiggle room, or anything. It spells it right out that if you want that, your client's supposed to be there. Now, it doesn't say that maybe you could do it by Skype.
Or phone?
Or, well, if the court's going to accept the phone, yeah. I mean, I think that presence can be broadly defined, but I don't think they specifically state you cannot do it by affidavit. So if you can get around and do it another way rather than just the affidavit, then yeah, you might be able to make that argument that technically, even though they're not physically present, they're present in court. Okay? I'm sorry, did you have, okay. I'm sorry.
Domestic violence definition.
Yeah. There's all different ways to do things. All right. There's been some changes in the municipal court rules, and you should be aware of them. They're not really earth-shattering or not. One of them is 752, which talks about motions to suppress evidence. It used to be that if it was with a warrant, it still had to be heard up in the law division, and the municipal prosecutor actually did do it. The prosecutor did it, the county prosecutor. However, now what they've said is that if it was a warrant that was actually issued by a municipal court judge, and it was within that municipal court judge jurisdiction, and the matter is now before that particular judge, then it can be heard in municipal court. If there are two judges in that particular municipality, they want another judge to hear the warrant suppression motion. If there is no other judge, they want the assignment judge, the presiding judge of municipal court to act as the judge. Basically, they don't want the judge who issued the warrant saying, yeah, I didn't screw up, I did a good job, you know? So they want someone else to say, yeah, he's fine, he did a good job, because, you know, the idea that a warrant that the judge screwed up is really not going to happen very often. So you've got that. What they talked about, though, is that there is going to be a warrant, there's going to be a motion brief requirement. If you file one and there is a warrant, you have to file the defendant's brief with your motion now. And the state must file a motion brief in response. There's supposedly 10 days. I doubt that they'll ever make that. But we'll see how that works out. But it's not discretionary. It's mandatory.
Now, without a warrant, though.
Without a warrant, it's still the judge's discretion.
Right, but you don't have to file a brief without a warrant. They have to.
Well, my experience, not like I've been practicing as a defense attorney all that long, it's been a little over 3 years, but my experience is that a lot of the judges require the defendant to file the brief first. It isn't right, but it's the judge, and really, you don't get very far arguing with the judge.
Because if there's no facts in dispute, you're not even supposed to get a hearing.
I understand that too, but they don't seem to know that either. I don't think they read the rules that much. They're kings and queens in their own little fiefdoms. And you really don't have much recourse. Think about it. You're kind of at their mercy. Because not only are they the king and the queen, but they're the executioner and the judge and the jury and everything else. So they do everything. So you got to do what they want. But technically, yeah, you're right. If it's a warrantless search, the burden is on the state to prove that the warrant is good. But we still have those problems, not even just in municipal court. We have it with law division judges too. And I'm like, I'm not doing it. I am not going to fight that first brief. I keep fighting it because I'm like, I'm going to think of better arguments than they are, and then I'm going to have to shoot them down. I'm not doing it. So I refused. And so we're playing games now, but I'm still waiting for the brief, so we'll see what happens. Dial subpoenas, if it's issued in a municipal court matter by that municipality, they can also be heard in municipal court. Once again, it would have to be by a different judge than the one that made it. Okay. Oh, and then there's this 772. They added this D, and it's relief requested by certain incarcerated persons. If the person is unrepresented, the person is entitled to ask for some type of relief from the court on an approved AOC form. And within 45 days of the court's receipt of that particular form, the court is supposed to do whatever, or handle, or hear, or resolve whatever the issue is. They're very non-specific about it. But the court has to respond in some manner within 45 days according to the court rule. So, it's very amorphous. You have to read it. It's very strange. But anyway, those are the new amendments to the court rules down on the municipal part. Okay. All right. Remember, I told you please were one of the themes of the Supreme Court. Well, they are. So we have State versus Urbina is a very interesting case to read. And basically, what it says is that when the person allocutes, if the person talks about having some possible defense, you can't just fluff that aside. You have to address it as a judge. Okay? So in this particular case, it was some type of an assault or a murder. It was a violent crime, and he said, yeah, I did it, but I did it because he was coming at me, and I thought he was going to hurt me or kill me or whatever. And the judge is like, yeah, okay, but you did do X, and he's like, yeah, I did it. Well, they said that he had a self-defense in there. It was very clear that he wasn't saying that he was guilty. They're saying you really can't let innocent people plead guilty. They were very emphatic about that part. If you're only supposed to let guilty people plead guilty. Okay. You know, that's what they say. So they played games with it. It's an interesting read. But they were very specific about that. So if by pleading guilty you are waiving self-defense, then it needs to be in the plea allocution. So you need the court or the defense attorney or the prosecutor, somebody who's present in the court, has to address this defendant and say, you have a possible self-defense, affirmative defense of self-defense. Are you aware of that? Yes. This would mean that if you could prove, you know, that you would have to raise it and the state would have to prove it beyond, you know, disprove it beyond a reasonable doubt. And, you know, if the state couldn't meet its burden, that you could be found not guilty and you could be found, you know, you could just then walk, you would not have any, you know, legal, reliable, you know, responsibility for this whole thing. And, you know, you have to go through it. The judge has to go through it. Somebody has to go through it. It has to be on the record. And the person has to say, yes, I've been advised of that by my attorney. I'm aware of it. However, you know, because of this, I'm waiving it. I don't feel that I have enough evidence. I think the state can meet its burden. Whatever you're going to have the person say, they have to say, because there has to be a knowing and voluntary waiver of the right to assert that at the trial. And the person has to be made aware of the fact that they are giving up this right and the repercussions of that waiver. Okay? It's once again, it's something that you should really read as Irvina, because it really does. It's really good about guilty pleas and what you really have to do, especially if there's a potential defense that the person is going to be waiving. Okay? State versus Gregory. State versus Gregory is kind of interesting. It goes with State versus Tate, and both of them are where their factual bases are found to be inadequate. And what the court holds in both of these is that when a person is pleading guilty, the person has to allocate to each and every all elements of the crime or crimes that he is pleading guilty to. And it has to be, you know, count one is this, these are the elements, that person has to allocate to that. Count two, these are the elements, the person has to allocate to that. The person either has to speak and say it in open court, whatever the particular elements are, or the person has to acknowledge that the element is present. In Gregory, it was a within 1,000 feet of a school zone case. During the allocution, for the guilty plea, the prosecutor made the representation that the event occurred within 1,000 feet of a school zone. And they require, under Gregory, the defendant would be required to acknowledge that what the prosecutor said is correct. Okay? So it's okay for him to make that representation, but then the defendant has to affirmatively acknowledge it as part of the plea to prove that element in there. Both Gregory and Tate distinguish itself from State versus Mitchell, which is the PCR case about PCR out of time. It talks about that you can look at the state in order to show that it was a knowing and voluntary, and there's sufficient factual basis for the entry of the plea. You can look at stuff outside the actual plea allocution and colloquy, the entire colloquy. You can look at like the pre-sentence report, the judgment and conviction. You can look, as long as you can prove that there really was sufficient facts to support it and that the defendant was aware of all those facts. In Gregory and Tate, they say no. You can only look at what's in the actual plea allocution. And it has to come, you know, that when I was a prosecutor, it used to drive me nuts, from the lips of the defendant. Well, they're actually meaning it literally now, okay? And I used to say, that's such BS. I can't believe it, you know. But now they're really saying that, okay? So you've got a Supreme Court decision that really is reinforcing that. So they are really holding not just the state, but the defense attorneys to making sure that there is a very good factual basis for your client. Now, this is all on direct appeal. And they haven't really addressed whether on a PCR, you're gonna have this exacting standard and must, or you can still, under a PCR, Mitchell still is gonna control. So be aware of that for your arguments. So you may be wanting to do that. And the other thing is here is in Gregory and Tate, they say that specifically that in order to make a motion to withdraw the guilty plea under this thing, lack of factual basis, you do not need to do a Slater analysis. You don't have to do the 4 prongs. You don't have to assert innocence. You don't have to do anything. It doesn't mean you can't, but it's not necessary if there is a lack of a factual basis. Okay? So that's really important because it's a much easier standard to prove that all the elements aren't there than it is to try to find out some, I'm asserting innocence and I have a decent defense if I do win my motion. Yeah, try to think of that sometimes. Yeah, okay. What's your defense? I don't know. I'll think something. Okay, so that doesn't always work so well, but this is good. Perez talks about, this is a luring case, an enticing or luring. The thing that I liked about Perez was about that they make a huge discussion about CSL and PSL, and a lot of times we use those terms interchangeably. And they say that you can't, that there are distinct post-sentencing schemes that go with each, and you can't use them interchangeably, and you can't use like a CSL remedy on a PSL case and vice versa. You have to know which one you're talking about, and you have to look at the distinct remedies for violations that go with each of the different schemes. Okay? State versus Lipa is a pre-sentence motion, and this is based upon ineffective assistance of counsel. This goes to show what a really lazy counsel can do for the defendant. Get him a really great deal. However, the ineffective assistance of counsel and also physical impossibility were proven in the motion to withdraw guilty plea. The guy had surgery, and according to the victim, he had climbed up a tree and through a second-story window in order to sexually assault this little kid. And the guy couldn't climb, because of the knee surgery, he couldn't climb a ladder. He just couldn't get up there. And also, it was ineffective assistance of counsel because there was DIFUS records from this particular incident. The defendant never even made the request or asked for an in-camera review. And he failed to investigate 2 prior false allegations that were made by this particular victim. He knew about them and did not pursue them. So this guy was he wasn't effective. Let's face it, that's just what it was. So this guy gets his plea back. And once he goes, I don't know what's going to happen with that. That should be interesting. It'll be interesting to see if the state actually pursues it after he's proven physical possibility to climb the second-story window. I'm curious. And last but not least, State versus Ashley. This is a reported decision, yay, Monmouth County. There's a lot of Monmouth County cases on here. I was surprised to see. Some of them were good for the state, some were not so good for the state. This one was not so good for the state. Mr. Ashley was part of the crowd that attacked the family attorney up in Red Bank. He was responsible for that. He and his cohorts. He ended up pleading guilty, without an open-ended to the court. There really was no plea agreement that was entered into by the state. There were some misstatements by the court about the plea agreement, but there really wasn't any plea agreement with the state. So the defendant gave his factual basis and the court was accepting them. The prosecutor actually did object to the factual basis and pointed out to the court that he felt that the factual basis were inadequate as to certain counts. Well, yes, and he was right, they were, and the court said that they were. And because of that, the court finally later on overturned those convictions and negated them, and then they finally were dismissed. However, the court then proceeded to enforce the remaining pleas of guilty. even though the whole was not upheld. And the court said, no, just because there was no plea agreement, it's not going to change it. It's an all or nothing. If you plead guilty and part of the plea is bad, then the whole plea goes. If you don't, it doesn't matter if there's a plea agreement with the state or it was just an open-ended plea, it's all or nothing. So if it's all, then you get everything and everything's good. If part of the whole is bad, then everything is bad. And so he gets his plea back. So I don't know what they're going to do with this, but it should be interesting to see. Okay. State versus Roseman is an AG case. I believe it's an AG case. I shouldn't say that. It might not be, but I think it is. Mr. Roseman was the mayor of the town, and he and his wife got divorced, and inadvertently she remained on his insurance policy, and he was not aware of it, truthfully. He had sent a note to the town people telling them to take his wife off, and they failed to do that. And about 3 years after this went on, he finally found out about it, went to his wife, and they went, oh no. He went back, brought it to the attention of the town, paid back all of the overage charges and anything that she had been paid out by the insurance company, and was then promptly indicted for official misconduct. I personally could not believe that they actually found this to be a crime. I just didn't think there was any mens rea. But anyway, the guy applies for official, he's got charged with official misconduct, 2nd degree. He applies for PTI. They say it's an official misconduct. You can't get PTI. It goes up, it goes down, it goes up, it goes down. And they also reject the wife. And basically because they rejected the husband. There really was nothing about the wife individually that they even considered. They just said, yeah, we're not taking you too. So the Supreme Court said, this is really bad. You can't get a case where there's more compelling and idiosyncratic circumstances than in this particular case. This guy definitely deserves PTI, and you can't just reject the wife because he rejected him. You have to give each person an individual analysis, and she was entitled to it. And they said because this has taken so long, they didn't even remand it. They actually just ordered them into PTI and said pretty much this is what's going to happen. I really feel that there was no crime, but who am I? That's what I would have gone with, but once again, who am I? State versus KS, once again, with PTI, anybody can apply. Whether your client's charged with a 1st or a 2nd degree crime, and there's the presumption against, application and getting into PTI, that doesn't matter. It's only a presumption. It's not written in stone. Everybody has to apply, and then the person can be rejected. You can't pre-screen them and say, you got a 2nd degree crime, you're probably not going to get there, so you need permission. Monmouth County used to do that, and that's what resulted in State versus Green. That's an appellate. Well, it went up and it went back, and it's all over. But if you want to get a little bit better talk about it than KS, look at State versus Green. Okay. All right, I only have 20 more minutes. It's okay. State versus Witt. Tenno Flores is dead. The AG's office feels very vindicated. No, I love the dissent. The first line of the dissent is, this is the case that shows that persistence pays off. And basically, that's exactly what happened. In the dissent to Tenno Flores, Rivera Soda and Albin both dissented, which is kind of weird. And they basically said that this was a bad decision. It wasn't going to work. I mean, it's wonderful for the defense, but it was horrible for the state. And they said it wasn't going to work. It was impractical. It was too difficult to determine. It was causing people to have their cars seized and be left alongside the road, and it was just not a workable scheme. But, Our Lady said, Ginny Long said, no, this is great, and it's going to protect the defendants. Well, it really didn't. It did cause problems. So they kept trying to get it overturned, and so finally, in State versus Witt, they got it overturned. And Outwood wrote the opinion. He was very happy. He could tell he was kind of smug when he wrote it, So basically, we're back to State versus Alston, and exigency can be found basically in the fact that the automobile is something that is readily mobile. And we're back to the standard where if it can be driven and it can be moved, then it's definitely mobile. It doesn't have to be moving. It could be a parked car. All that stuff is still going to be good law. But it can't be up on blocks. It can't lack an engine, stuff like that. It has to have a steering wheel. It has to be drivable. Okay, so we're back to that. State versus Shannon reinforces the fact that the state really must make sure that if they have warrants and they've been satisfied, that you get them out of the system. Because that's what happened with State versus Shannon. That's another Monmouth County case, by the way. Yeah. Mr. Shannon, who was actually a really big gets off yet again on this one. So because the warrant was not valid, and so it just kind of went away. State versus Reese is a 911 call allows an officer to go in under the community caretaking or emergency aid exception to make sure that there's nothing wrong in the residence. It's basically it's a companion case with State versus Frankel, even though they're many years apart. Now, in your outline, it just says a drop 911 call. I disagree with that. I think that if you look at the facts of State versus Reese, you will see that there was more than just the drop 911 call. In Reese, the cops go to the door, the guy comes to the door, and he's got abrasions all over his hand, as though he's hit either a wall or an item or a person. They ask him what happened to his hands, and he's trying to say he hit a wall. And then they ask him if he's married, and he becomes very agitated. He acts like a jerk, and he gets very belligerent. He slams the door in their faces, and they basically say, we're coming in. They come in. They end up having a huge big fight with this guy. He hits the cops. He does all this other stuff. And then the cops, both of them, one cop is down. There's three cops. One cop is down on the ground. The other two are trying to get him off of the third cop that's on the ground and getting the crap kicked out of him by the defendant. And so both of the other cops actually punch this guy in the face, and that gets him off of him, surprisingly, yay. And the Supreme Court said, the Supreme Court says that was not excessive force. That it was okay for those cops to punch that guy in the face because they were in fear of safety of their third fallen compatriot. So it's there. Just be kind of wary about it, okay? State versus Wright talks about a land